Thank you, Your Honor. We are present in the matter of the State of Ohio versus Jonathan Williams, case 24-CR977. The defendant is present, represented by counsel Dan Williams. On November 18th, 2024, the State of Ohio filed a motion for leave to enter a nolle prosequi. We are here for the purposes of that hearing.
And what's the basis for the nolle?
The basis for the nolle is that we are requesting additional time to perform further investigation in the matter.
Okay, thank you. Dan Williams. Anything you want to place in the record?
Nothing, Your Honor. That's my understanding is that the state needs further time to investigate. We remain in open and active conversations with the state, so we would have no objection to the request to the nolle at this time, Your Honor.
Excuse me. Very well, then the court finds there's been good cause demonstrated, and I hereby grant the state leave to enter a nolle prosequi on this case. And I'll dismiss the indictment at this time for the reason that further investigation is needed by the state before it can go any further in this matter. So the matter is dismissed. Bond is hereby, if there was bond posted, it's hereby released. Was there money posted?
It was a personal cognizance bond.
Okay, then you don't need to worry about coming back to get anything. All right, anything else for the record?
No, thank you, Your Honor.
Nothing further.
All right, thanks.
All rise.
Toots.
Thank you, Your Honor. We're here today in the state of Ohio versus Brian P. Peluso, case number 24CR001085. Defendant is present in open court today with his counsel, Nicolette Tomaszek. Your Honor, we're here today on a motion for leave to enter nale proseque that was filed on December 4th of 2024. The state is asking for additional time for further investigation, and that is the state's understanding at this time.
Thank you. Has the case been indicted? Has not been indicted.
It has not been indicted.
So I got
It was
this as a
bound
reigning
over.
judge.
Yes.
Okay. Ms. Tomaszek, here to be heard at all?
Thank you, Your Honor. We have no objection to the state's request. Thank you.
Very well, then the court hereby finds that the state of Ohio has demonstrated good cause for granting the nale, and I hereby grant the defendant's motion, the state's motion for leave to enter a nale in this case for the reason that further investigation is required. Has there been any bond posted in this matter?
Yes, Your Honor. A bond has been posted.
A money bond or OR bond?
Money bond, I believe, Your
Okay,
Honor.
that will be released at this time. Probably not going to be able to get it today. I'm sure it's going to have some paperwork about to get filed, but it'll be available this week sometime. Okay. Anything else for the record?
No, thank you, Your Honor.
Nothing further, Your Honor. Thank
All right,
you.
Thank you.
All rise. We are hearing case number 24 CR 507, State of Ohio versus Robert Clark. We are set today for a sentencing. We were last together for jury trial back on the back in the 7th of November 2024, where the defendant was found guilty to both counts 1 and counts 2, aggravated trafficking in drugs. Count 2 being a felony of the third degree, count 1 being a felony of the third degree, count 2 being a felony of the second degree, carrying mandatory prison term. Your Honor, we are set today for a sentencing. State's had the opportunity to review the pre-sentence report in this case, as well as drug and alcohol, and is prepared to proceed today.
Thank you. Mr. Fatique, any reason not to go forward with sentencing?
No, Your Honor.
Anything you'd like to say on behalf of your client?
Oh, yes. Good morning, Your Honor. I've had an opportunity to review the PSR. We understand that this is a mandatory prison case, but I'd like to highlight the fact that Mr. Clark has no prior prison terms. He hasn't had a conviction since 2008. He was attending online college classes and was self-employed at the time of his arrest here. And you can see from the PSR, he admitted that he's had a long-standing problem with meth. And you could, in some of the conversations with the CI, he's talking about contracting jobs that he had. We'd respectfully request the court consider a prison term at the minimum end, 2 to 3 years. As we discussed in chambers, Mr. Clark is indigent. I will be submitting an affidavit of indigency on his behalf by the end of the business day today. Another issue I'd like to touch on, there were discussions between myself, Concetta Ragazzione, and Mr. Feusel about a possible offer of 2 F3s. That offer, the offer from the prosecutor was 1 F2. We had an opportunity to counter if we chose. Never got that far with Mr. Clark. He never got back to me. But I just want to make it clear that there was never an offer of 2 F3s that was made by the prosecutor to Mr. Clark.
Post-indictment.
Post-indictment, right.
There was an offer of 1 F3 made before indictment for an information, and he rejected that, correct?
Yes, Your Honor. But based on all that, again, we'd ask for a sentence at the minimum end.
Thank you. Mr. Clark, you have the right to address this court before your sentence. You can say anything you want. Is there anything you want to say at this time?
Yes, Your Honor. I'm sorry, I didn't know there was an offer, but
That's not true.
Is it okay if I read this to you?
You can do it, say whatever you want, but don't tell me there was no offer before this case ever went to the indictment and that you were offered an information, a 1 F3. That's not true, but go ahead.
No, I didn't say, I didn't know. I didn't know there was an F3. I wasn't told details.
That's not true. You were told, you rejected an information in this case before there was even an indictment of 1 F3. You rejected that.
No, I didn't know there was F3.
Go ahead, say whatever you'd like to say.
I can't really blame anyone for the position I'm in. It's all in that I did this. I put myself in this position. I wouldn't have been here if I wouldn't have started doing drugs. You know what I mean? And honestly, the drug culture is really easy to get into, and it's extremely hard to get out of. Matter of fact, nowadays it seems like people are dying to get out of it. Literally, it's horrible. I parted for myself a long time ago when I started doing drugs. I haven't been the man I was raised to be. I haven't been the man I was supposed to be. I've worked consistently, you know, and I've done a lot of good deeds, but being an addict, doing good deeds, doesn't make me any less an addict. It did make me a big hypocrite, but no less an addict. It's one of those, like, how dare I try to remove a splick of wood from someone else's eyes before I first remove a splick of wood from my own. Me and my lawyer, we being sober, you view the world a little bit differently when you're not high. Believe me, I know. Even the cell block looks different. First cell block, they held me and looked different today when I was in it from when I went in when I was high. Uh, I'm not a great man. Sometimes I'm not even a good man. I try to be a good man. I try to be a good father. I donate a lot of my time to church. I work hard. And excuse my language, but I effed up. I effed up badly. I gotta take responsibility for that, and I gotta do whatever time it comes with that. I understand that. I can't be mad at anyone but myself. I can't ask you for mercy because I've sat there and I've told people what not to do. You know what I mean? Not to do these same things that I did, which makes me even more of an idiot because it's like I knew I was messing up and I still messed up. I'm assuming, because you're a judge, that you've never had any of the addictive problems or addiction problems that I've had. It's rough. It's hard. It's really hard. By the grace of God, at least I'm here. I could be dead. I still have a life. I'm still alive. I have a chance to fix things with my daughter, with my son, with my family who's been trying to help me the whole time, with my girlfriend who signed me up for treatment right before I caught this charge. The day before I turned myself in, 2 days before that, we found out that she made plans for me to go 2 hours away to a treatment facility, and then we found out I had a charge, and I brought myself in, and that's when all of this began for me. I don't know where I'm going to be 8 years from now. I was talking to the guy in NA. He told me, you can't worry about being sober for the rest of your life. He says, it's too much of a burden to put on any man's shoulders. It's like, you just got to focus on being sober today. Today I'm sober. I feel good. I look better. I put on more weight. My head is clear. No one wants to go to prison. No one, including myself. No one wants to be in jail, including myself. No one wants to be a disappointment to their family. I don't. I was raised much better than this. Much, much better than this. I'm half the man I need to be. Well, I was half the man I need to be. I have a business plan. I was 3 classes away from getting my associate. It's not that makes me any better than anyone else with addiction, but it does, if anything else, at least let me know that I tried in some ways to do the right thing. I'm convicted of selling drugs. I'm not going to say I don't sell drugs because I wouldn't be convicted of selling drugs. But I don't make a profit or anything like that. I get high. I got high. That's no excuse. It's no excuse. I wanted you to know that I did, that I got high. I wanted them to know that I'm an idiot for getting high. I'm an idiot for getting high the very first time. I'm an idiot for allowing it to continue. Am I a bad person? I hope not. I want to go to heaven. I want to do the right things. I want to be a good person like everybody else. Is it harder for me? A little bit harder. Being sober staying away from drugs is really hard. I didn't even realize there was a drug culture, but there is. There's a drug culture or subculture, whatever you want to call it. And once you get sucked into it, the people that are around you, I'm sitting in jail and I'm listening to people talk about how they can't wait to get out and get high. And all I can think about is, wow, it feels good not to be high. You know what I mean? My brain moves at 100 miles a minute. I'm having ideas. I'm thinking about business plans I did. I'm refining ideas I had so that I could do better when I can get out. And then I listen to them and I'm like, how did I allow myself to get here? How did I allow myself to be surrounded by some of these people? Some of the people have been great influences. I don't know where this is going to lead. I know it's going to be better. I can honestly say that. I'm not happy about being here, but I'm happy about being alive. I'm happy this, then so be it. You know what I mean? At least I've gotten that. I'll do whatever time I have to do. I'll grow. I'll continue on. I'll try to be the best man I can be, the best father I can be, the best boyfriend, future husband I can be. You know, I wish my family would have made it here. I think there was a little confusion with them at the time because they've tried to help. They've thrown hints. They sent work my direction to keep me preoccupied, and I owe them just as much an apology because they invested in me. You know what I mean? They're truly invested in me and my life and making sure that I do well. My grandmother just passed away. They buried her on Monday. Or last Wednesday. I missed the funeral. I'm here. I mean, my great aunt, her funeral, she's not doing too well. This has been horrible. It's not just been horrible for me. My actions have had a major effect on my family and anyone else that looked out for me. I just been wasted the court's time. The court has so many people to deal with. You know, I mean, dangerous people. You know, it's just, I'm here taking up the court's time. I didn't have the right to do that. There's so many people that need help. There's so many people. I added to an existing problem. I didn't help them. I didn't help it. Even when I thought I was helping, I wasn't helping. I'm in this county. It has some of the best mental health resources and apparently some of the best addiction resources. So in that aspect, I'm lucky. You know, I could be somewhere else where I'm not saying the other counties don't care, but it could be 10 times worse. It could definitely be 10 times worse. You know, I hope that I'm better. I hope that every day from now continues to get better. I plan on staying strong. I plan on staying focused. It doesn't matter if I'm in prison, in jail, free. I know that I'm going to need treatment, and I'm going to seek it. I'm going to keep going to group no matter where I'm at because it feels good. It feels right. It's been a long time since I felt good. I put weight back on. I looked at myself and I looked better. You know, I apologized to my lawyer when we got together today. I know I've probably just been a pain for him. You know, an absolute pain. And he sat here through my attitude and, excuse my language, me being an ass. He still sat there and he's still trying to help me out. Right now, he's still trying to help me out. You know what I mean? I owe him a great apology. I can apologize all day for everything I've done, but the court didn't have that kind of time. But before I got sent inside, at least I wanted to at least tell everyone how sorry I am. You know, it's detrimental. I like to thank you guys. As bad as it sounds, dude, literally, the guy smoked weed that was laced with something. He dropped dead. You know, and was lucky enough to be brought back. I could not feed him. You know how horrible that would be for my family, my daughter, my son. For me to just be gone from a dumb decision. Thank the court for my time. I wrote something. I didn't like what they said. It just didn't feel right. Thank you.
Thank you, Mr. Clark. Mr. Fatika, anything else on behalf of the defense?
No, thank you, Your Honor.
Mr. Floysel for the state of Ohio.
Thank you, Your Honor. Your Honor, the second count in this case does carry a mandatory prison sentence. As it being a felony of the second degree, it would be a minimum of 2 to 3 years. Your Honor, the defendant, despite not having a record, has shown his a prior prison record, has shown his inability to handle any type of control. By his own admissions, he had been using drugs on November 6th. That's during the trial. Methamphetamine and cocaine, I think, was the use that he admitted to to the probation department, to the counselor. Screens came back positive, essentially violating his bond while he was on it. So despite maybe not having that big felony history, what he does have is, while he's been with this court, a consistent, has shown an inability to follow the directions of the court. Your Honor, I don't think again, this is a mandatory prison case. I do think prison is appropriate. The location where the buy took place on the second count of this case occurred within the designated range of a school zone within Fairport Harbor. And I would ask that prison be imposed in this case. Thank you.
Thank you. This court has reviewed the pre-sentence report and investigation, the drug and alcohol evaluation. I've considered the facts and circumstances from the offenses involved. Obviously, I presided over the trial, so I'm very familiar with those. I've considered everything said here in court today by Mr. Fatika, the prosecutor, Mr. Clark himself. This is all being considered by this court in light of the purposes and principles of felony sentencing, which are set forth in 292911. As for the factors in 292912, nothing stands out factually about the case based on my consideration of the evidence at trial that makes the offense any more or less serious than what normally constitutes these two offenses of the degrees for which the defendant was charged. As for recidivism factors, court finds, defendant does have a history of prior criminal convictions. There's a drug abuse problem that relates to the offense. Defendant has not done anything to address that or hadn't done anything to address that. Court further finds defendant violated conditions of his bond by continually using drugs while on bond. As for factors indicating recidivism is less likely, the court will note that the defendant did lead a law-abiding life for a significant period of time. I think his last conviction, if I'm remembering correctly, was 2009. Let's see.
2008, I believe.
2008, okay. Yeah, 2008, and that was just a traffic, careless driving. I'm not sure really what that involves. All the convictions are from out of state. Court finds that count 2 in this case is subject to a mandatory prison term. Prison is consistent with the purposes and principles of sentencing. Therefore, it will be the sentence of this court that on count 1, defendant serve a term in prison of 18 months. On count 2, defendant serve an indefinite mandatory term of imprisonment of a minimum of 2 years, maximum of 3 years. I run those two counts concurrent with each other. So the overall term is an indefinite mandatory term of a minimum of 2 years, maximum of 3 years. He has credit for 42 days that he has already served. I need to advise you, upon your release from prison, you will be placed on post-release control for 18 months, up to possibly 3 years, at minimum 18 months, and could be up to 3 years depending on what the parole authority determines. When on post-release control, if you violate any of the conditions of your supervision, the parole authority can return you to prison as punishment for violating the rules for another 9 months for each violation you commit, up to an overall maximum of 50% or half of the prison term I just imposed. Any additional prison term imposed for violating post-release control is being imposed as part of the sentence at this time. To pay all costs. There's a mandatory fine on each count. Count 1, a fine of $5,000, which is the minimum. I could fine up to 10, but I'll fine the minimum fine on each of $5,000 on count 1, $7,500 on count 2, for an overall mandatory fine of $12,500. If the court receives an affidavit of indigency, I will accept that, and that will be waived. But at this point, it's in place. Order the forfeiture of the contraband and instrumentalities that were part of the forfeiture specifications. I need to advise you, Mr. Clark, that there's a rebuttable presumption that you will be released from your prison term after the minimum term is expired. So after you've served the 2 years less the credit that you have, there's a presumption that you will be released at that time. And that's not guaranteed. That's what rebuttable means. If the prison officials believe while you are in prison that you've misbehaved and committed rule infractions in the institution, that you're a threat to society, that you haven't been sufficiently rehabilitated, they can have a hearing to determine that you should be kept in longer than the minimum sentence. You have a right to be at that hearing if that should happen. If after that hearing they determine that you have committed infractions of the rules while in prison, basically misbehaved while you were in there, they could not let you out at the minimum sentence. They'll select a new date at that point to let you out. There'll be a presumption that you get released at that new date. Same thing could happen, however, if you've continued to misbehave, not sufficiently rehabilitated, they can deny you your release at that time. Under no circumstances, however, can you be kept in beyond the maximum sentence. Even if you misbehave the whole time you're in there, they'd have to release you after the maximum 3 years. Further need to advise you that you do have the right to appeal the conviction in this case if you desire. Specifically, you do have the right to file an appeal, and if you're unable to pay for the cost of an appeal, you have the right to appeal without payment. You have the right to obtain counsel for an appeal, and if you cannot afford counsel, again, one will be appointed for you without cost to effect your appeal. If you are unable to pay for the cost of the documents necessary for an appeal, which would include a transcript of all the proceedings that we've had here in court, documents and the transcripts will be provided you without cost, and you do have the right to have a notice of appeal timely filed on your behalf. Do you know at this point whether you want to file an appeal, Mr. Clark?
Yes.
Okay. I will appoint an attorney for you. It won't be the public defender's office. It'll be a new attorney to appoint you to represent you on your appeal. So that will be done here. Mr. Fatika, all I ask is that you make sure if that's not taken care of prior to the notice of appeal having to be filed 30 days, that you protect that right. I think that covers everything. Mr. Foysel, is there anything else for the record?
Nothing further, Your Honor.
Mr. Fatika,
No, thank you, Your Honor.
thank you.
All rise.
Thank you, Your Honor. We are present today in the state of Ohio versus Rambo Harna, case 24-CR-914. We are present today for a change of plea hearing. The defendant is present with counsel Patrick Leary. The state anticipates that the defendant will withdraw his formally entered plea of not guilty and enter a plea of guilty to count 1 in the indictment, that is theft, a felony of the 5th degree. Further, the state anticipates that the defendant will waive his right to a pre-sentence report and request to proceed directly to sentencing. The defendant does have 16 days of jail time credit.
Thank you, Mr. Leary. Does that sound accurate?
Yes, it does, Your Honor.
And Mr. Harna, were you able to hear what the prosecutor just had to say regarding what she believes your intentions are here at this time?
Yes, Judge.
You could be seated at this time. I don't interpret that as any disrespect. It's just easier to be sitting down. But move a little closer so we can hear you better. All right, that's good. You were able to hear what she said?
Yes, Judge.
She indicated to the court she believes that your desire to withdraw your previously entered plea of not guilty and plead guilty to the 1 charge of theft, a felony of the 5th degree in the indictment, and we would then be proceeding straight to sentencing. Is that your understanding of the discussions that took place between your lawyer and the prosecutor and what you want to do today?
Yes, Judge.
Well, before I can accept your plea, I need to make sure you understand everything going on here. I need to make sure you understand what you're charged with in pleading guilty to, the rights you have that you give up by pleading guilty, as well as all the possible penalties that you could face by pleading guilty. So for me to determine those issues, I will ask you a series of questions. If at any point when I'm asking you the questions, if you're unsure, unclear of anything I'm asking you, if you need anything repeated or clarified, if you want a moment to speak with your lawyer so you could ask him questions, or even if you want to ask me questions, make sure you let me know that, because I need to make sure you understand everything going on, all right?
Yes, Judge.
All right. Well, let's get started then. How old are you, sir?
32.
32?
Yes, sir.
Are you able to read and write the English language?
Read, write, yeah, it's okay. I can read.
You can read it?
Yeah.
Any difficulty with that?
No, I can read.
Writing some issues?
Yeah, some
Okay.
issues.
But you can read it well?
Yeah, Judge.
Do you understand what it is that you read in English language?
Yeah, Judge.
Okay. You're able to speak the English language?
Yeah, Judge.
And you can understand it okay?
Yeah, Judge.
Any difficulty with that at all?
No, Judge.
Mr. Leary, do you have any concerns in regards to your client's ability to understand and speak the English language?
No, Your Honor. I've spoken with him over the phone a number of times, and again in person. I believe he understands exactly what's happening here today.
And you feel comfortable with being able to understand me and to communicate?
Yeah, Judge.
All right. Are you a U.S. citizen?
No, Judge.
Sorry?
No, Judge.
Okay. I need to advise you that if you are not a citizen of the United States, that conviction of this offense, which you're about to plead guilty to, may have the consequences of deportation or exclusion from admission to the United States or denial of naturalization pursuant to the laws of the United States. You understand that?
Yeah, Judge.
Would you like any additional time to talk to your lawyer about that issue?
No, Judge.
You're prepared to proceed, being advised of that?
Yeah, Judge.
Before coming into court here this morning, have you any drugs or alcohol of any kind?
No, Judge.
What about within the last 48 hours?
No, Judge.
Not even prescribed medication,
No,
nothing?
Judge.
Now, you would have been served with a copy of the indictment previously. Do you remember getting that? That's the document that sets forth and explains what the charge is.
Yes, sir.
Did you have the chance at some point to review that indictment?
Yeah, Judge.
Now, in that indictment, you're charged with 1 count. And what's alleged here is on or about January 7th, 2024 in Eastlake, Lake County, Ohio, that you did with purpose to deprive Walmart, who is the owner of certain property, being various merchandise, that you knowingly obtained or exerted control over that property by deception. The value of that property was over $1,000, but was less than $7,500, which makes the offense theft, a felony of the 5th degree. Do you understand what you're charged with and pleading guilty to in this count?
Yeah, Judge.
Any questions about it?
No, Judge. I'm very sorry for it.
But do you understand the charge
Yeah, Judge.
and what you're accused of doing?
Yeah, Judge.
Okay. Well, before I can accept your guilty plea, I need to make sure you understand all the rights you're giving up by pleading guilty. And you first of all have a right to have a trial. Now, a trial could be to me as a judge, where I would listen to all the evidence and I would make that decision whether you're guilty or not guilty. But you also have a right to have a jury trial. And a jury trial would be in front of 12 citizens here from Lake County who would listen to all the evidence that either side wanted to present. Those 12 jurors would consider and weigh all that evidence, and those 12 jurors would make that ultimate decision. And that ultimate decision reached by those 12 jurors would have to be unanimous. And what that means is all 12 of them would have to agree together, one way or the other, guilty or not guilty, in regards to this charge. You understand that?
Yeah, Judge.
You understand by pleading guilty or giving up your right to have a trial?
Yeah, Judge.
Now, if we had a trial, you'd have the right to have an attorney represent you at that trial. If you could not afford an attorney to represent you at a trial, this court would appoint one for you free of charge to do that. Do you understand that?
Yeah, Judge.
Now, at a trial, the prosecutor here would be representing the state of Ohio, and she would have what we would call the burden of proof. By her having the burden of proof, what that actually means is that it's her job, or she bears the responsibility or the obligation to prove you guilty at a trial before you could ever be found guilty. You're presumed innocent of this charge, and that presumption of innocence sticks with you and it stays with you until the state, if at all, was ever able at a trial to overcome that presumption and prove you guilty. Do you understand that?
Yeah, Judge.
Now, when I talk about this burden of proof, since this is a criminal case, that burden is what we refer to as proof beyond a reasonable doubt. And that is the highest burden of proof there is in our justice system. What it actually means, it's the amount of the evidence and the quality of the evidence the state would have to present at a trial to prove you guilty. So in this case, the state would have to present evidence to prove each element or each part of the charge beyond any reasonable doubt before you could ever be found guilty of that. Do you understand that?
Yeah, Judge.
Do you understand by pleading guilty or giving up your right to make the prosecutor prove you guilty beyond a reasonable doubt?
Yeah, Judge.
Now, in order to do that, or at least to try to do that, if we're going to have a trial, the prosecutor would bring witnesses into the courtroom to testify for the state by answering questions from the prosecutor. Once those witnesses answered the prosecutor's questions, then your lawyer would have the right on your behalf to ask those same person's questions. We call that cross-examination. He could ask him anything he wanted to within certain rules. Do you understand that?
Yeah, Judge.
Do you understand by pleading guilty or giving up your right to cross-examine or confront these witnesses that would come in here and testify against you?
Yeah, Judge.
Now, you'd also have the right at a trial. You could call your own witnesses to come to court and testify for you if you wanted to and answer your lawyer's questions. Now, you don't have to do that, and you're not required to do that, but you have a right to do that if you wanted. Do you understand that?
Yeah, Judge.
And you further can request this court issue an order. We call that order a subpoena. What a subpoena would do actually is force or make someone come to court to testify for you and answer your lawyer's questions if they weren't willing to come in voluntarily on their own. Do you understand that?
Yeah, Judge.
Do you realize you're giving up that right?
Yeah, Judge.
Now, you also have the right at a trial. You could choose to testify on your own behalf if you wanted to, but you also do have a right to not testify if you don't want to. That's a decision or a choice that you and you alone would have to make. Do you understand that?
Yeah, Judge.
And since that's your choice, what that really means then is that nobody else could force you or make you. Nobody could compel you to testify against yourself at a trial if you didn't want to. I can't make you testify, but most importantly, the prosecutor here, she would not be allowed to call you as a witness at your trial and make you get up on the stand and answer questions and testify. Your own lawyer can't make you testify if you didn't want to. Do you understand that?
Yeah, Judge.
Further understand that if we went to trial and you were found guilty of this charge, you would have the right to appeal or challenge that guilty finding to a higher court, a court that sits above me and reviews my decisions. By pleading guilty here today, you are giving up or waiving any right you have to appeal a guilty finding. This court will enter if your plea is accepted, as well as any other issues you could have raised or brought to my attention up to this time. Do you understand that?
Yeah, Judge.
All right, well, do you have any questions for me regarding, regarding these rights we've just talked about? These are all the rights you have and all the rights you're giving up by pleading guilty. Any questions?
No, Judge.
Do you understand them all?
Yeah, Judge.
Do you still want to plead guilty?
Yes, Judge.
You understand a guilty plea is a complete admission of guilt. It means you're admitting to the facts being alleged by the prosecutor. We're not going to argue you didn't do it or that it's someone else's fault or anything like that. Do you understand that?
Yes, Judge.
Further, as a result of pleading guilty, the effect of that plea is you're going to be found guilty by the court and then you will subsequently be sentenced by the court. Do you understand that?
Yeah, Judge.
Now, as far as sentencing goes, you're pleading guilty to a felony of the 5th degree. This offense is punishable by a possible term in prison of a minimum of 6 months, a maximum of 12 months, or any whole number in that range of 6 to 12. Do you understand that? So 6, 7, 8, 9, 10, 11, or 12 months in prison. Do you understand that?
Yeah, Judge.
Do you have any other charges pending against you anywhere right now? I know you're serving a sentence, but any other open pending charges?
No, that I know, sir.
Okay. You're currently serving a federal prison sentence, correct?
Yes.
Okay. I need to advise you that if I impose a prison sentence in this case, I do have the discretion or the right to or authority to run my prison sentence concurrent or consecutive to the sentence you're serving. So concurrent means you'd serve it together at the same time. So while you're serving the federal sentence, you'd be serving the state sentence at the same time. Consecutive means one after the other. You'd finish serving the federal prison sentence first, and once that's done, then you'd come and serve the full time of the state sentence. You understand the difference there?
Yeah, Judge.
So your maximum sentence in this case, I need to make sure you understand that, is 12 months, and it could be consecutive to the time you're currently serving now. Do you understand that?
Yeah, Judge.
If a prison sentence was imposed in this case upon your release from prison, you could be placed in what we call post-release control. It's sometimes referred to as parole. It's a period of supervision you would be on after you served and completed the prison sentence. In this case, it could be for up to 2 years. Do you understand that?
Yeah, Judge.
And if you were on post-release control and you were violating any of the conditions of your supervision, the parole authority could send you back to prison as punishment for violating their rules for another 9 months for each violation you commit, up to an overall maximum of 50% or half of whatever the prison term was imposed by this court. Do you understand that?
Yeah, Judge.
So in this case, that would be 6 months would be the most that they can send you back for. Do you understand that?
Yeah, Judge.
Now, aside from the possible prison sentence I just mentioned, there's other sanctions that I could order. You could be fined up to $2,500. You could be ordered to pay court costs. You can also be ordered to reimburse the county for any cost of confinement, community supervision, or treatment, if any of that were applicable. Do you understand that?
Yeah, Judge.
You could also be ordered to pay restitution to the victim, Walmart here, for any economic loss they may have suffered as a result of the conduct involved. Do you understand that?
Yeah, Judge.
A few moments ago, I explained the possible prison sentence. I used the word possible. Prison's not mandatory in this case. You are eligible for probation or what is called community control sanctions. Do you understand that?
Yeah, Judge.
You understand just because you're eligible doesn't mean you'll be put on probation. It means it would be considered if that's what you were asking for. I'd look at all the information, then make the decision I thought was the right thing to do. Do you understand that?
Yeah, Judge.
Lastly, when we do proceed to sentencing, you will have the right at that time to say anything you want. Anything you want me to know or consider. Your lawyer's allowed to speak on your behalf. He can recommend a sentence to the court and say whatever he wants me to know. The prosecutor also has a right to recommend a sentence. Do you understand that?
Yeah, Judge.
Do you understand that whatever anyone says at sentencing regarding what they think the sentence should be, it is just what I said. It's a recommendation. I don't have to go along and follow that if I didn't think that was the right thing to do. Do you understand that?
Yeah, Judge.
All right. Well, do you have any questions for me at all regarding the potential penalties you face and what can happen at sentencing?
I'm very sorry, sir, for what I did. What did I do?
I understand. And you're going to get a chance to say anything you want here shortly. But I want to make sure you understanding what we just talked about. So I just explained all the possible penalties that could happen at the time of sentencing. Do you understand all of them?
Yeah, Judge.
Do you still want to plead guilty?
Yeah, Judge.
Have you had enough time to talk about this case with your lawyer, Mr. Leary, and have him go over everything with you and answer your questions?
Yeah, Judge.
Are you satisfied with his advice and counsel?
Yeah, Judge.
Has he or has anyone promised you what's going to happen at sentencing, which is inducing you to plead guilty?
No, Judge.
Have you been threatened or forced in any way to plead guilty?
No, Judge.
Are you entering this plea here today freely and voluntarily?
Yeah, for me.
All right, then, Mr. Harn, any questions for me at this time regarding anything we've just talked about? What you're pleading guilty to, the rights you give up by pleading guilty, the possible penalties you face, the consequences in regards to not being a citizen. Any questions for me at all?
No, Judge.
Do you need any more time to speak with your lawyer before you go forward with the plea?
No, Judge.
And what we're going to do at this time is the prosecutor here, she's going to explain for me what the facts are in this case. If we had a trial, what would be demonstrated? I need you to listen to her because I'm going to have some questions for you about that, all right?
Okay, Judge.
All right. Ms. Tuttle?
Thank you, Your Honor. Had this case proceeded to trial, the state would have proven beyond a reasonable doubt that on the 7th day of January 2024 in Eastlake, Lake County, Ohio, the defendant entered Walmart with another individual. They proceeded to the electronics department, selected multiple electronics, and proceeded to the cash register. They were paying in cash. They used sleight of hand tricks and deception to distract the cashier and underpay for the electronic goods. The amount of underpayment was $6,005. The individuals left the store underpaying for those items.
What happened to those items?
Some of the items were returned to other Walmarts in different states for cash value. Other items were not recovered.
So none of them were recovered.
None of them
and
were recovered in
returned
Eastlake.
without being money going out.
Correct.
Thank you. Mr. Harner, were you able to hear what the prosecutor here just had to say regarding what she believes the evidence would show if we had a trial?
Yeah, Judge.
What, if anything, do you have to say about that as she just represented them to the court? Are they true? Did you do what she said?
Yeah, Judge.
Very well, then, regarding count 1, charging you with theft, a felony of the 5th degree, what is your plea to that count?
Guilty.
All right, I have in my possession at this time a document. There's 4 pages here. It's called a written plea of guilty and judgment entry, which explains everything I've just explained to you. Before I can accept your guilty plea, I need to make sure you understand this document and that you sign it here in court. Now, my understanding is before I came out here onto the bench, you had a chance to go over this document with your lawyer. Is that correct?
Yeah, Judge.
I'm sorry?
Yeah, Judge.
Mr. Leary, is that accurate? Did you read this to your client and review it with him and answer his questions?
Yes, Your Honor.
Did he indicate an understanding of it to you?
Yes, Your Honor.
Is that correct, Mr. Harna?
Yeah, Judge.
So you understand what this document says?
Yeah, Judge.
Do you have any questions for me about what it says?
No, Judge.
Now, it looks like on the bottom of the 3rd page that you signed the document. Did you, in fact, sign it?
Yeah, Judge.
Mr. Leary, you witnessed that?
Yes, I did, Your Honor.
Ms. Tuttle, you as well?
I did, Your Honor.
Very well, then. At this time, the court will accept the defendant's oral and written plea of guilty. Let the record reflect the defendant was here in open court with his lawyer, advised of all his constitutional rights, made a knowing, intelligent, voluntary waiver of those rights. The court also finds the defendant understands the nature of the charge, the effect of the guilty plea, as well as the maximum penalty that can be imposed. Finding this to be knowing, intelligent, and voluntary, the court will accept the defendant's plea, finding the defendant guilty of count 1, theft, a felony of the 5th degree in violation of 2913.02A3. Mr. Leary, is there any reason not to go forward with sentencing at this time?
No, Your Honor. In fact, we would waive the preparation of a pre-sentence report and investigation as well.
Very well, then. Is there anything you care to say on behalf of your client?
Yes, Your Honor. May I have just one moment?
Sure.
Thank you very much, Your Honor. On behalf of Mr. Harna, obviously, as you've heard a number of times during the plea recitation, as we were going through that hearing, Rambo is very remorseful for his role in what occurred back in January of this year. In fact, I think he expressed a number of times that he's very sorry. My conversations with him over the phone and in person and even through other family members, he's always expressed the same thing and has been nothing but desirous of resolving this matter with the plea at the appropriate time, which is clearly today. Judge, also to that end, because he has kind of a close-knit family and familial group here in the States, they have made possibility the restitution in this matter. I think I have indicated to the court and to the prosecutor for the state of Ohio that we are in possession of a bank check in the amount of $6,005 to the Walmart Corporation, which will be taken care of after this hearing, Judge. So we do have restitution to be taken care of in full to make Walmart whole. Judge, my client came to the States, I think he indicated to me approximately about a year or so before this incident took place. He is the father of 4 children, currently the ages of 12, 8, 7, and 5. The 12-year-old judge, I do have documentation of it, but at the time, certainly after that child was born, the mother of that child gave up custody and guardianship to my client, Rambo Harna. So he is the sole and legal custodian. I have had an opportunity to speak with my client regarding his children. All 4 of his children reside in Romania with his current wife, who is the mother of the other 3 children, and his parents. As I've indicated to this court, to the prosecutor, Contessa, the 12-year-old, does have some medical issues which have required hospitalization and or surgery. And so I just wanted to make the court aware of that. She is in Romania right now, living with his parents. Obviously, Rambo is eager to get back to Romania at some point in time, hopefully the quickest way possible, so that he could be there with his family and, most importantly, be there to address the needs of his daughter. It's my understanding, Judge, through the documentation that I received, that medical issue developed while he was here in the States, and I believe prior to his, around the time of his incarceration on his federal case for reentry. So this is not something that was pre-existing, his coming to the United States. So, Judge, for that reason, he has accepted responsibility. He came here under the desire to find work because he had indicated to me that work is somewhat difficult and not as well paying over in Romania. He came here to seek employment and hopefully to send money back to his family. Got involved with some people that he obviously should not have gotten involved with and got himself in this situation. He has expressed to me, and I believe to this court, and I think he will again, his genuine remorse for the situation. I'd ask the court to consider all of the available options for sentencing, but I would ask for a compassionate sentence, Judge. If the court is inclined to issue a prison sentence, in this case, I'd ask the court to take into consideration that we have or are about to make restitution in full to the Walmart Corporation, but I would ask for a minimum sentence, and I would ask for a concurrent sentence with his federal time, Judge. We know that there's a deportation order in place, so when he's done serving cumulatively all of his time, no matter where and what it is, he's going to be deported back to Romania, which is what he's desirous of anyway. He wants to be able to be back with his family and to certainly show care, love, and support for Contessa, who's going through these medical issues. So I'd ask for a compassionate sentence, Judge, and a minimum sentence concurrent to the federal time. Thank you very much, Your Honor.
Thank you. 1 second, please. Stan? Thank you, Mr. Larry. Mr. Harna, you do have the right, as I told you a little bit ago, and this was the time when I was referring to say anything you want. Anything you want me to consider or you want me to know before sentence. Is there anything you'd like to say at this time?
I'm very sorry, sir, and I want to go to my family.
Anything else you want to say? Sorry?
No, sir.
Mr. Leary, anything else on behalf of the defendant?
No, Your Honor.
Thank you. Ms. Tuttle for the state of Ohio.
Thank you, Your Honor. The state is recommending a prison sentence to be served concurrently to the time that he's serving
Concurrently?
consecutively to the time he's serving in his federal case. That's case 1:24 CR 00297.
Can you say that again, please?
1:24 CR 00297.
Good.
The reason that the state is requesting that this be consecutive is that it's separate and distinct conduct for the case that the defendant is currently serving a prison term. He has had at least 3 prior charges from the federal government for alien inadmissibility or illegal reentry in 2016, 2018, 2022, and 2024. So the fact that he has a deportation order in place does not show to the state of Ohio that he intends to go back to Romania or to stay there with his family, as that hasn't been his pattern for the last decade. Additionally, the conduct that he engaged in here was not an isolated incident. This theft from Walmart was not his only theft from Walmart. He was well known to the Walmart loss prevention department. There are a number of other incidents in which they have flagged Mr. Harna as committing this type of conduct. There may be other warrants out for his arrest. I'm just not sure out of which jurisdictions. But there is an allegation that he and the other individual that he was with have engaged in this conduct throughout the entire United States. So for that basis, we would ask that there be a prison sentence consecutive to the time that he's currently serving. We do appreciate the full restitution of $6,005 and would ask that the court enter a judgment for that restitution. And he does have 16 days of jail time credit. Thank you.
Is there any, obviously I'm familiar with the current sentence, from based on what you told me, he's currently serving a sentence for illegal entry, and this is the 3rd deportation order, from what I understand. Mm-hmm. What other record, if any, are you aware of?
He has 1 prior felony theft out of the state of New York.
Okay. Thank you. The court has considered the particular facts and circumstances of this offense, the nature of this offense. I've considered what's been said here in court by Mr. Leary, the prosecutor, the recommendations from both sides. The defendant was afforded an opportunity to address the court. I've taken into consideration what he has had to say. This is all considered by this court in light of the purposes and principles of felony sentencing set forth in 29:29:11. So the factors in 29:29:12, I find that the victim suffered serious economic harm. As far as F5 shoplifting theft cases go, this is on the more serious side, right up to the very close to the maximum for an F4. Nothing makes it less serious. As for recidivism factors, the court finds the defendant has a history of criminal convictions. He's currently serving a federal prison sentence for illegally coming into this country, which is at least the 3rd time that he's done it. There's a deportation order for him right now, which is the 3rd deportation order that he has. So you say you want to go back and be with your family and do that, but you keep coming over here. Keep coming over here and committing crime.
I'm not gonna come in no more, sir.
Well, that doesn't carry any weight with me because you've
daughter's
said that before, and
My
you just
daughter's
keep coming
sick,
up. I
sir.
don't understand.
Don't interrupt the judge.
Nothing makes indicates recidivism is less likely. Court finds the defendant currently is serving a prison sentence. He waived the pre-sentence report. Prison is consistent with the purposes and principles of sentencing, and the defendant is not amenable to any available community control sanction. Therefore, it will be the sentence of this court that the defendant serve a term in prison of 8 months. I will run that concurrent with the sentence he's currently serving. He has credit for 16 days in this case. That's concurrent to federal case number 24 CR 1:00297. An order of restitution in the amount of $6,005. Defendant's order to pay out costs. Need to advise you, Mr. Harn, upon your release from prison. Technically, you can be put on post-release control for up to 2 years. If you are and you're violating those conditions, the parole authority can return you to prison as punishment for violating the rules for another, in this case, 4 months, the maximum being 50% of the term I just imposed. Any additional prison term imposed for violating post-release control is being imposed as part of the sentence at this time. I will release bond at this time as well. There was a bond posted in this case, correct?
There was,
Yes,
Your
Your
Honor.
Honor.
So that will be released. That covers everything. Is there anything else for the record, Ms. Tuttle?
No, Your Honor.
Mr. Leary?
No, Your Honor. Thank you very much.
Mr. Leary, I'm going to ask that you stick around for 1 second. Probation officer's on their way over, and speaking up, makes it easier that we don't have to deal with that then. So if you could turn that over to him, that'd be great. All right, thank you.
Thank you very much, Your Honor.
One second. All right, we are present in case 24 CR 1299, State of Ohio versus, is it Jared or Gerard? Gerard Rood, R-O-O-D. We're scheduled for a competency hearing today, as well as I'm going to conduct a hearing on a request that I received that was filed by the defendant for a pro se motion for new counsel. In regards to the competency evaluation, this is pre-indictment. The matter has not been indicted yet. That's why I am addressing it as the arraigning judge at this point. Upon receipt of the motion, the court referred the matter for an evaluation. The evaluation has been completed. Counsel for each side has been provided a copy of the evaluation. I met with counsel in chambers prior to coming out here on the bench. Counsel for each side indicated they were stipulating to the report and the findings contained therein, which is that the defendant does understand the nature of the offenses for which he's charged and is able to assist in his presently capable of assisting in his defense and is therefore competent. Party stipulating those findings in the court based on the stipulation in the report has found that the defendant is in fact competent at this point to stand trial. The court did receive, as I indicated, a letter from the defendant which was actually filed on November 14th, a month ago. The court did not address this at this point as there was a competency issue that was pending. That's been resolved. So I'm going to address this with the defendant at this time as he is here in open court at this point. Mr. Chad Mulkey is here as defendant's counsel, and Taylor Linden is here representing the state of Ohio. So Mr. Rood, you filed this letter, this motion for new counsel, so I'll let you be heard on that at this time. Why is it that you believe or that you want a new attorney appointed at this point?
Yes, Your Honor.
Now, I've read the motion in the letter, but I'll give you an opportunity to be heard here at this time.
Well, the first problem that I have with Chad being my lawyer is he's a public defender. The public defender's firm represented the victim. This is in a case about 3 months ago, and as I know, this is vicarious representation. He's really not supposed to represent me. Furthermore, the victim had a case 3 months ago where she came to court, and not to put the victim's information out there or nothing like that, but she came home to be a confidential informant. And I went to her bond hearing, and I was against the decision for her to be not to be a confidential informant, but I was against her decision to come home because she was hacking my cell phone. All of it's on record in the court proceeding where I was there. On record, it's in my cell phone. It's in my cell phone. I have a cell phone that tells me that a detective named Detective Chris told me when my girlfriend came home that the public defenders represented her and they were trying to work out a deal with the public defenders and the prosecutor and all of them for her to come home and be a CI. Like, I have that all on my cell phone as text message in my phone. And I keep telling this man this, and he keeps trying to represent me.
You have text messages on your phone that say what?
A Detective Chris is telling me that they worked out a deal with the victim's public defender and the prosecutor and the judge for her to come home. And the probation department.
For the purpose of acting as a CI against you?
No, it's just as a CI. That's not the point that I'm trying to make. Clearly, he's not supposed to represent me. That's vicarious representation.
What do you mean? I've never heard of that term, vicarious.
Vicarious representation is when their law firm has represented a victim, and it's the victim in your case. He's not allowed to do that.
Never heard that term before.
Also, furthermore, Me and him have gotten into it because in my preliminary hearing, my 6th Amendment right and my 14th Amendment right were clearly violated on record. Clearly, because he wasn't supposed to represent me, and I said it in open court, and the judge kept allowing him to represent me, even though my lawyer stood up and said he wasn't supposed to represent me.
Your lawyer in the municipal court said he wasn't supposed to represent you?
Yes.
I wasn't at the preliminary hearing, Your Honor. It was Bill Watson from our office.
Bill Watson said he wasn't supposed to be representing him?
I reviewed a copy of the video of the preliminary hearing. I didn't hear anything I didn't hear those words, or at least that I recall hearing anything like that.
How, Your Honor, I have a copy of the same tape he has. I've watched it 3 or 4 times. Every day, almost every single day, I ask to see
a video of the preliminary hearing?
Yes, and it says it clear as day. He stands up and says he can't represent me. Well, he says it, and then even when he was cross-examining the cop, he said on the stand that he couldn't even continue to represent me. On the stand, and he kept going. I have cell phone footage of my innocence. Cell phone footage.
In regards to that part, that's irrelevant right now for this issue. But let me go back to this. You're the victim. Who is the victim to you, if any? Is there a relationship there?
Yeah, Brandy Hudson's. That's my girlfriend.
Okay. I don't know anything about this case, Mr. Rude. I just...
Every time I ask this man...
So, hang on. What's her name? Brandy Hutchins?
Yeah.
Okay. So she is the alleged victim in your case?
Yes.
Okay. And she had her own issues or trouble with the courts here?
Yeah, she had a possession case.
Okay. And the public defender's office represented her?
Yes.
Okay. And I'm just making sure I understand everything here. You're saying that you believe and you have evidence that she worked out some type of agreement, or her and or her attorney, the public defender, Lake County public defender, correct?
Yes.
Worked out some agreement with law enforcement that she will be released from jail, given a lower bond, or somehow released from jail to work as a confidential informant for the law enforcement?
Yes.
But not to get you, but for something else, something unrelated?
Something else.
Okay. And what is the status of her case right now, if you know?
She's still on probation.
Is she got charges pending, or the case is resolved?
Case is resolved.
Okay.
As I read the law library, he's not allowed to represent me regardless if the case is resolved or not. It says it's clear as day. It's vicarious representation.
You have that law?
Yeah, I've seen it in the law library.
What'd you say?
I've seen it in the law library.
It's clear as day?
Yeah, it says it right there.
I'd like to see that. I'd like to show me that. Mr. Mulkey, what do you know about this?
Your Honor, I've looked into representation of the alleged victim by our office in this case. There were some older closed cases. I believe one was a child endangerment case back in 2021, I want to say. Now, we did have her currently on a community control violation.
For that 21 CR case?
I think it was for a child endangerment case. I think there was another case where there was a drug possession charge that was reduced to a misdemeanor as well, and a probation violation.
In municipal court or in this court?
In municipal court, Your Honor. Isabella from our office was handling the community control violation. I sent her an email to withdraw from the community control violation. It doesn't appear to be in any way related to this case, but it does appear to be related to the alleged victim that he's saying.
It's related to me.
I'll let you talk. Let's one at a time. I can't hear both of you.
That's all I have at this point on that issue, judges. Isabella indicated she would be withdrawing from that case.
What did you say the victim's name is, alleged victim?
Brandy Hutchins.
Hutchins?
Yes.
Well, she doesn't have any. She's never had anything in the common pleas court.
She had a felony 5 in common pleas court, and they dropped it to a misdemeanor.
Well, they dropped it. It never got to common pleas court. It would have been in municipal, it could have been charged as a felony in municipal court, then they dropped it to a misdemeanor there. It's never been to this court. She's never, I'm just put her name in here. She's never been in this common pleas court. I'm going to tell you what I want to do. I want you to send me that. I'll ask Mr. Mulkey, get me that. I want to see that video from the preliminary hearing.
There's more on that tape.
I'll watch it. I'm not going to base any decisions on, I'm not here to judge the merits of whether you're guilty or not guilty or anything like that. I'm here to address your issues you're raising in this regarding the attorney issue.
Can I say another thing that he's done to me? He's hung the phone up on me 3 or 4 times over the phone. One time, he mocked me for how he thinks African Americans talk. He said, okay, bruh, I'm hanging the phone up now, bruh. And he hung the phone up on me. Like, he's done this multiple times. Among motions I need filed because of the preliminary hearing, and he won't do it. He's told me over the phone, he's like, no matter what, the judge in a preliminary hearing can do whatever he wants. And that's clearly not true. A judge is supposed to be impartial. The whole time, he's not supposed to show partiality or nothing. Like, he's supposed to be impartial. He's supposed to hear me and the prosecution. He didn't even hear me, and he keeps telling me the judge can do it. That's what his defense mechanism every time he talks to me. Like, he doesn't respect my knowledge for the law. It's like a lawyer only knows what they know because they read law books. If I read exactly what he's reading, I can know exactly what he knows. No. And he doesn't respect my knowledge. It's like he's dictating my case.
All right. Mr. Mulkey, you care to address any of those allegations?
As it relates to the phone calls, we've had some good times and some bad times on the phone together. I know there's a cutoff time limit on the jail phone calls as well. I know he did speak to Vanessa at one point, and she did in that call, Your Honor. Regarding it, there has been somewhat of a rocky relationship. I won't go into the details regarding client confidentiality, but his trust seems to be very, very limited. I do just have a concern that will interfere with his ability to assist me in the preparation of a defense, Your Honor.
That's a choice he's making then, because he's been found competent to stand trial, and he has the ability to assist counsel. So if that happens, that's an issue that's an issue he's creating for himself.
Certainly, Your Honor. And I do have a copy on CD. Would a CD work? I have an extra copy on CD. I can bring that to the court. And for the record, I do want to say, we did deliver.
In regards to these phone calls that were alleged to have been made that you hung up on them, I don't want the details, obviously, or specifics. But what was his attitude or towards you at the time of these phone calls?
Your Honor, as most recently as last week, his attitude was good. There have been times in the past where the attitude...
I'm talking about the hang-ups. Are you saying you never did hang up on him?
I didn't hang up on him, no.
Yes, he hung up the phone on me when I asked him when my motion for new counsel was going to be filed, and he hung the phone up on me saying he was going to give me a competency hearing. Just flat out hung the phone up on me.
Mr. Mulkey?
I may have ended a conversation with him regarding that issue, but I don't look at it like a hang up in the middle of any sort of middle of a sentence or a conversation or anything like that. There wasn't a lot I could advise him of. All the competency was pending until we got the results of that back. I was familiar with the fact that he had filed a motion for new counsel as well, indicating that he wasn't happy with the representation at that time.
Well, Mr. Rude, you have the right to have an attorney appointed to represent you. You do not have the right to have pick and choose who your attorney is, or have an attorney appointed and say, I don't like this one, give me another one. You can't do that. But I'm going to take a look at least at this video. I want to see it, and then I'll make my ruling. Is there anything else for the record at this time?
Thank you.
One last thing. If I wanted to go pro se, would I be allowed to go pro se?
You'd have to file a motion for that, and then a court would have to conduct an inquiry of you to make sure that you are able to represent yourself. So that's up for you to say. That's how that would work. That probably wouldn't get done until after an indictment. And I'm not necessarily going to be the judge on this case. I have 25% chance of being it. There's 4 judges here. Once it's been indicted and you've been arraigned, and the judge will be assigned to the case, that judge would address that issue. But you can file a request like you filed this motion if you want. I'm setting forth your reasons for that.
Okay.
All right, thank you.
Thank you, Judge.